my DNA and all.
You got out
before I got out.
hang on. You got out when? The 3rd of September?
Yes. Okay. And before I get out, they swabbed me and they took my blood for DNA and put it on record. I don't know why it's taking so long.
But it's not his DNA, it's DNA
From the scene.
from the scene, right? So when they swabbed you, yeah, that has been done. Court calls the case, People versus Thamar Jones.
Are you reading it to the people?
Apparently, yes.
Tanaji Carey, I can really, on behalf of Mr. Thamar Johnson, Mr. Johnson, state your name for the record.
Lamar Johnson.
Thamar. We're asking for an adjournment, Your Honor.
Probable cause conference, March 5th, 2026, 9 a.m. Bond continued.
Okay, Your Honor, I apologize. Okay, there is a piece of evidence that we were still waiting for. I had spoken with my client previously. We said we were going to set for exam. Once I spoke with the prosecution today or yesterday, they informed me that they're still waiting on that. I wanted to adjourn. It's some DNA evidence. Yes, my client would like to, he wants to move forward with the preliminary examination even without it.
And for what we're going to reach out to the OIC and provide with the date when we're going to get that back. They said soon, and I don't know how to interpret that. They
Sure.
I mean, I'll set it, but you understand, sir, that if it comes in, it's not going to be the basis for an adjournment because we know that it's missing.
I mean, Your Honor, I've been waiting,
Yeah, I hear you. I wish DNA could be done faster. It just, there's some logistical reasons and others that it can't be done that quickly, but
You're okay.
no, I'm just saying, I just got out of the joint on the 23rd, on the 3rd of September. And they
say
took my
again,
DNA and all.
you got out,
before I got out.
hang on. You got out when? The 3rd of September?
Yes. Okay. And before I get out, they swabbed me and they took my blood for DNA and put it on record. I don't know why it's taking so long.
But it's not his DNA, it's DNA
From the scene.
from the scene, right? So when they swabbed you, yeah, that has been done. It's the DNA from this scene that's the problem.
That's what they're trying to. No. So what do you want to do? Do you want to wait or do you want to set?
I mean, I'll do whatever you want me to
He
do,
wants
but
to
pardon?
He wants to set it, Judge.
Okay, I can do it 2 ways. So I can have it set. I could set it later out so you can see if it's gonna come in, because I don't know what soon means.
Neither. Left a message with haven't heard anything.
So I'm gonna have lots of good night.
I'll check. I'll check.
So what do you want me to do? You want me just to set it and hope for the best, or? I mean, I can,
I've been waiting.
one thing, right, but one thing I can do is I can go to the 5th like we were planning. If it's not, then just remind me and I'll just kick it out to my next date, which would be the 24th, which would be right around that same time, just to see if this stuff gets in, because it may exonerate you. I guess that's part of the problem, so.
Oh, the 5th? I think we're fine with that, Judge.
We're doing it that way?
Yes, yeah.
Okay, so I'll set it the 5th for probable cause conference. Just remind me that, or what I just said, that if it's not back then and you want it set, I'll just kick it to my date and we'll go from there. How's that sound? Fair enough? Yeah. Okay, thanks. Bond.
Fair enough.
For the court draw near, the Honorable Judge Simpson.
You may be seated. Mr. Cook.
Good morning, Your Honor. Raymond Cook for the people. Your Honor, people believe any potential.
Excuse me one moment. People? Thank you. Go ahead, Mr. Cook.
Thank you. Your Honor, people believe any potential conflict between this honorable court and the office of the public defender. All people do not believe that any such conflict exists. We make this waiver in the avoidance of all doubt.
Thank you.
Good morning, Your Honor. Joy Haynes, Senior Assistant Public Defender. Your Honor, we too do not believe that there is any conflict, and if there is a conflict, we would waive.
Thank you. Court, for its part, also does not believe there's a conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people of the state of Michigan versus Romeo Smith.
First Assistant Public Defender on behalf of Mr. Smith, who I believe is appearing by Zoom. Mr. Smith, please state your name for the record.
I'm Lamar Smith.
Okay, he did.
Thank you, Judge. I believe we are in receipt of a competency finding. And I believe that should be in the court's possession. I
Yes,
think we're prepared to stick to those findings.
and that's the February 4th.
Yes,
date,
Judge.
February 4th. So the defense stipulates, people stipulate to those findings. All right. The court, in reviewing those findings, would find that the defendant is no longer incompetent to stand trial and therefore competent to stand trial, that he can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. I have signed the order to that effect. And what would you like this next set for?
Thank you, Judge. You would not mind please setting it for PCC. We greatly appreciate it.
I'll set a probable cause conference for March 5th. 2026, 9 a.m.
Thank you, Judge.
Bond will continue. Thank you. Calls case people versus Avion Johnson.
Carolyn Foster Tucker on behalf of Avion Johnson, standing in for attorney of record at Drukas.
And I had this as in custody. Where is he?
He is in custody.
Oh, there he is. Mr. Johnson, can you state your name, please? If you just talk, Mr. Johnson, I think you're unmuted, sir. Mr. Johnson, can you hear me? I don't think he can hear me. Is that okay?
Yes, sir.
I don't know, because I'm not hearing any background noise there at all. I cannot hear him. All right, can you try to send him a message that will pass this matter and call him back up that you're emailing? So he'll see that on the screen. Maybe, hold on. Oh, okay, gotcha. I can't even tell if he can hear me. Or if it's just, we have no sound. Mr. Johnson, if you can hear me, just wave your hand. Yeah, he can't hear me. All right, I'll pass. You're gonna email them. All right, I'm gonna pass.
Okay.
Court does call the case People versus Jawan Crawford.
Yes, good morning, Judge Alan Cooper for Joanne Crawford.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
You're going to discuss a matter with my client. He's agreeable to waiving the preliminary exam.
Your name, sir?
Juwan Crawford.
And you're gonna waive your preliminary examination?
Yes, sir.
All right, you understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand that you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on the 2 counts.
Your Honor, may I
Counsel,
address
you
the issue of
acknowledge-
bond again?
Well, let me do the arraignment and then I'll do that. Do you acknowledge receipt of the information, waive its reading?
Yes, Your Honor.
And at this time, your client stands mute.
Yes, Your Honor.
Defendant having waived formal reading, standing mute to both counts. Court will enter a not guilty plea. I will set circuit court pretrial for
March 2nd at 1:30 with Judge Mood.
March 2nd, 2026, 1:30 before Judge Hamoud. Yes, that's the bond.
Yes, Judge. I made this request last week as well. My client, unfortunately, he had a difficult time with his employment over the past 2 or 3 years. He was injured. However, he has been seeking employment. He actually does have a job offer letter substantiating that he's got a job waiting for him. Now that letter is from a company called Real Truck, indicating that his start date was actually supposed to be the day before yesterday, but he thinks that if he follows up with him, he might still be able to get this job underway, which is obviously significant because the whole crux of this case is to get some kind of payment schedule. If he's not working, then he can't work out a payment schedule with the prosecutor. So I understand that there's been some non-payment over the past year or so. That's because he has been unemployed, but now he actually does have employment. He's trying to properly put this matter behind him. So I think the fact that he actually does have a written job offer is good cause to reduce the bond. I would like a personal bond because that's all he can afford. The family is in court. There's no risk of flight. He's got 5 brothers and sisters. All of them have tried to talk and try to compile some, even the 25%. None of the family members can come up with this. So it's going to be up to Mr. Crawford to actually try to get payments to work something out ultimately when he deals with this felony child support case. So because he's got this job waiting for him, it's solid, it's confirmed, it's in writing. I would just ask that the bond be reduced to a personal bond, and let's deal with the matter at circuit court.
Are you saying the 25,000 that was listed on the complaint was only non-payment for a year?
Yes.
Is that what you're indicating, counsel?
Your Honor, I didn't do all the math on it. I think his support was set at about $1,200 or $1,500 a month.
Yes.
And I'm not sure if it was for 1 year. I think it was over a period of 2 years, or maybe a year and a half or so.
I mean, the difficulty is that the statute, I mean, I hear your argument, but the statute very clearly dictates 25%. I'm not sure that a job offer, and this court wouldn't find that a job offer in and of itself is going to constitute good cause, but do the people have
otherwise than what you're doing, then you're looking at punishing him for basically what he's actually charged with.
I'm not punishing him.
in.
He didn't pay for his child, so don't put it on me.
Well, in effect,
If you don't pay for your children, this is what happens. This is the punishment for doing that. So don't put it on the court or anybody else. The legislature made the statute. It says 25%. I'm not punishing him for anything. If he doesn't meet the standard of good cause, he doesn't meet the standard of good cause, counsel. Do I have a response from the people?
Yes, Your Honor. I would agree with you. We would ask that you deny modification of the bond specifically to a PR bond. Again, as stated last week and as stated today, lack of payment, promise to pay, to me, in my opinion, is not good cause to modify the bond. While the defendant was out and free and not under course, not incarcerated, he had the opportunity to pay. The amount that accrued is now at $32,000, over $32,000, and that was over a few years. So we have no guarantee that just releasing him and him seeking a possible employment opportunity will guarantee payment. And for those reasons, Your Honor, we would ask that you deny modifying the bond today. Thank you.
This is nothing different than I heard the last time that he was here, and quite frankly, the court in it would be of rights to up his bond because the amount is now higher than it was in the complaint, but I'm not going to do that. I'm going to leave it where it is at this point, but I'm not going to find that there's any good cause. Once again, motion for bond reduction is denied. Bond will continue. Thank you.
Thank you.
Court calls case, People versus Stephen Javon.
Michael Gaddy, Assistant Public Defender for Mr. Gavon, Your Honor.
Here. Ron,
You want to state your name? You want to state your name?
Mr. Javon, state your name. Oh, I see.
He's refusing at this time.
He's refusing. Okay, but
Yes, sir.
that is Mr. Javon according to your records. Officer,
Your Honor, I think this is a competency review. I didn't receive any kind of,
I didn't receive a report either.
I did try and see Mr. Gavon and he refused me yesterday.
He refused it. Okay.
Judge,
Yes.
is this the case where we adjourned so we could do a casual and he's had a finding a number of months ago, but has refused to come out to court? I don't remember the case.
I believe that, yes, it is, he's not, the last opinion is he's not competent to stand trial, but he is at least present via here. I think the last time he wasn't coming up, we did not have any communication with him, but I would consider him to be present at these proceedings now. Since he's appearing via tablet, although he doesn't want to say anything. So I'm going to, is there any other additional evidence regarding finding of competence?
There is, I don't have anything further, Judge.
Anything
As I
from the
said,
people?
No, Judge.
Court would find that the defendant at this time is incompetent to stand trial. I will sign an order to that effect.
I'll type that up and send it to the court.
Well, I have an order that I signed.
Thank you.
I'll set a competency review hearing for, give me 90.
May 14th.
May 14th, 2026, 9 a.m. Bound continue. Thank you. Court calls case People versus Derek Hunt.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Assistant Public Defender Chelsea Vergils with and on behalf of Derek Hunt.
Get out the way. Come on, Mr. Hunt. Mr. Bird is just lingering in the eye. Just.
Please state your name.
Derek Hunt. Oh,
Your name, sir.
Derek Hunt.
All right.
Your Honor, we're asking to adjourn this to continue a plea discussion.
Probable cause conference in this matter will be adjourned to March 12th, 2026, 9 a.m. Bound continue.
Thank you, Your Honor.
Thank you.
Thank you.
Court calls case People versus Nikita Griffin.
Good morning again, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Assistant Public Defender Chelsea Vergils with and on behalf of Nikita Griffin. Mr. Griffin, please state your name.
Nikita Griffin.
Thank you.
I'm here. Your Honor, I believe Mr. Griffin would like to waive his right to a preliminary exam after a plea discussion. The offer he's interested in would require him to waive this.
Sir, is that correct that you want to waive your right to a preliminary exam?
Yes, it is.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
I do.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution. You understand that? All right. People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over on 2 counts. Mr. Deals.
We acknowledge receipt of the information, waive its formal reading, and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for
March 19th at 1:30 with Judge Slay.
March 19, 2026, 1:30 before Judge Slay. Mr. Giles, anything regarding bond you want to accuse me of keeping him in?
I don't believe so. I think the bond is set.
I know that was unfair. Is there anything regarding bond, Mr. Giles?
No, thank you. Your Honor.
All right, thank you. Bond will continue. Thank you, sir.
Thank you.
Is that it for Attorney General or she got more? That's it? All right. Thank you, Madam Attorney General. Court calls the case of the people versus Ashley Albert. That's why it went sideways. Constantino was over there, but see, I didn't even see her.
Yeah,
It was Gaddy. Gaddy was blocking.
it happens a lot, Judge.
Okay.
Believe it or not.
Go ahead.
Christina Costantino appearing on behalf of Ashley Elber. I believe she is appearing via Zoom. Ms. Elber, can you please state your name for the?
Ashley Elber.
Oh, there she is. Okay. All right, you're seeking an adjournment.
Yes, Your Honor. I was just appointed to Ms. Elber's case late last night, so I do not have discovery. I also need to have an opportunity to meet with her and discuss her matter. So I would be asking for an adjournment of the probable cause conference.
Probable cause conference objection will be adjourned March 19th, 2026, 9 a.m. Bond continues.
Thank you very much, Your Honor.
Thank you.
Thank you.
Thank you, ma'am. Court does call the case of people versus Braisha Anderson.
Assistant Public Defender Jay Bellinger on behalf of Ms. Anderson on cases ending in 5640 and 5026, Your Honor. We're also aware of the bond violation this morning.
Yes,
Hi.
Your Honor. Brandon Bird on behalf of Bryce Anderson on the case ending in 5330.
And Ms. Anderson, can you please state your name for the record?
Bryce Anderson.
And Your Honor, as to the PCCs on this matter, we would be asking for an adjournment. I have spoken with the prosecutor. He's looking for a mitigation on this, which I'm happy to draw up, but that will take a few weeks.
Here, Your Honor.
All right, so you want me to adjourn that and the bond violation or?
Your Honor, after speaking with our client, it's my understanding that she is willing to plead guilty to the violation this morning. We do have an explanation.
Adjourn to probable cause conferences then to, will the 5th be enough time for you to get done what you need to get done, or do you need the 12th?
I would need the 12th, Your Honor.
Adjourn these to March 12th, 2026, 9
I'm gonna come meet with you so we can.
As to bond, I guess, the court having accepted her plea guilty to the violation.
Respectfully, Your Honor, our client wasn't able to get in the house in which she was living. So her tether died. Am I correct?
Yeah. Our understanding is that she has a roommate, Your Honor. Her roommate locked her out of the house. Her phone was in the house. Her tether died. She wasn't able to get back into the house and charge it. She does apologize to the court for the violation. She really had no way to do it. As to the missed test, Your Honor, again, she didn't have a phone at the time. She couldn't call.
Did she not have the charger? Or
she did not have the charger that was in the home.
Did she go to community corrections?
She did not, Your Honor. She had no way to get there, and she otherwise would have called them. However, her phone was in the house. Is that correct as well? Okay.
Well, what actions did she take to try to get it charged?
I just tried to get back into the house and I just tried to try to find it. Try to have her give me the charger or throw it through the window or something, and she wouldn't let me in.
Where was the house was located? Where?
It was the one on Packer. It was the apartments on Packer.
It's a pretty tumultuous relationship with the roommate, Your Honor.
Okay, I get that part of it, but I guess what I don't understand, if she's on Packard, why she didn't just walk over to community corrections?
I honestly didn't even know I could have just come over and just said like, hey, I didn't have the charger. I really just didn't know that. I rather was trying to get it.
Well, where is the charger now?
Still in the house.
So if I were to let you out, where would you? Well, first of all, you didn't appear was one of the things. Why didn't she appear? for the hearing.
Your Honor,
The last hearing, the jail, did say that my client wouldn't come out to cell. Now, after speaking with Ms. Anderson, Your Honor, she's been very polite to me. She has been very polite, and I believe we're able to work together now to get some of those issues handled. That's one of the reasons why we're trying to put in this mitigation report for mental health issues. My client does suffer from mental health issues, Your Honor, but she understands that she has to show up to court. She understands where she doesn't want to be at this time.
Okay, when she's locked out, where was she then? And when she was locked out, where was she?
I was on the password.
what did you do when you were locked out of the house? You were still at the house?
No, I ended up going over to my godparents in-laws. Ended up going over there and staying over there for a minute, and then going back to my apartment every day trying to get into the apartment. And that's where I got arrested as.
Okay, so when you went to your godparents, did you ask them to give you a ride to community? I mean, I guess I'm not understanding.
I never thought to come up to community corrections because I have to call a number, right? You can't just come up. You have to call the number, and the number says your number or color, and then you come up. But without my phone, then without the charger, I just didn't do it. I never thought to just pop up and come up. I didn't think to do that. It just wasn't in my mind to do that. I get what you're saying, but I just really honestly didn't think to do it.
Your response?
No objection to a release for treatment, but I do have concerns for this defendant's own well-being. On the new case, the 26 case, in that report, the defendant indicates she attempted to harm and kill herself using drugs. So I'm concerned that when you don't have testing and there's this prior history of an attempt to use those drugs to commit self-harm, we might not see this defendant again if released on her own without any sort of supervision. So I think release to treatment would be good and appropriate, but otherwise I would ask.
Would you be okay with a release to treatment? Is that something you want us to?
Yeah, right.
Okay. Your Honor, after speaking with my client, it's my understanding that she herself would be okay with the release to treatment. So I'm happy to submit an order to the court.
All right. So what I will do is
I can submit it on your case too.
I'm going to continue her bond at the amount it's at.
I'll get that
They'll
done.
sign once presented to me in order to release to treatment.
I'll include you on the email.
I'll also adjourn the sentencing on the violation to the March 12th date. So I'm not going to sentence her on that. I'm just going to leave everything where it is. We'll get the order. If she can get released to treatment, that'd be great. I think that might be the best thing.
Okay, thank you very much, Your Honor.
Thank you.
Okay, I'll be in touch, okay?
All right, thank you.
Thank you, Mayor.
Sweetheart.
Mr. Johnson. Yeah. As recalls the case, people versus Avion Johnson.
Sherilyn Foster Tucker on behalf of Avion Johnson, standing in for attorney of record Ed Drukas.
Mr. Johnson, can you state your name?
Avion Johnson.
Okay, now we have you. Okay. You don't have any problem with Miss Foster Tucker appearing for your counsel of record?
No, Your Honor.
All right, thank you, sir. All right.
And Your Honor, Mr. Drukas is seeking an adjournment. I believe they're close to a resolution.
Got it. All right. Probable cause conference will be adjourned then to March 5th, 2026, 9 a.m. We'll continue. All right.
Thank you, Your Honor.
All right. Thank you, Mr. Johnson.
Thank you.
Court calls the case of the people versus Harold Couch.
And good morning, Your Honor. Joseph Hall appearing for and on behalf of Mr. Couch, who now stands to my right. Mr. Couch, if you could state your name for the record.
Harold C. Couch, Jr. He's waiving.
That's correct statement, Your Honor.
Sir, you're waiving your right to a preliminary examination?
Yes, I am.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, I do.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, I do.
People also waive their right.
Yeah.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Mr. Hall.
Your Honor, we waive formal reading, stand mute at this time.
Defendant having waived former reading, standing mute. Court will enter not guilty plea. Pretrial will be set for
April 15th at 1:30 with Judge Conlon.
April 15, 2026, 1:30, Judge Conlon. Bond will continue.
Thank you, Your
Thank
Honor.
you. Court calls case of the people versus Edna Grima.
Please, Honorable Court, Brandenburg, on behalf of Edna Gurma. Ms. Gurma, please state your full name for the record.
Excuse me, Edna Joy Gurma.
Thank you. What are we doing?
Respectfully, Your Honor, I just got appointed to this matter. We're gonna ask for.
And you're not ready? No, go ahead. I'm sorry. My bad.
We're gonna ask for adjournment on this, on this matter.
All right.
I'm gonna have to turn in my green sheet.
You don't have it?
I don't.
What have you been doing? Besides, never mind.
Don't do me
Probably-
like that. Don't do me. like that.
Probable cause conference. I'll just adjourn it out in 2 weeks, let you get caught up and do that. Okay, Ms. Gurman?
Gotcha.
March 5th, 2026, 9 a.m.
And permission to address bond, Your Honor.
Yes.
Respectfully, my client did have she did drop dirty. She doesn't want to make any excuses why, but she wants to move forward and knows that she can move forward. 61 years old, been through a lot in her life, but she's trying to she is trying to make things right. She has a Stop the Gun Violence Outreach Program that she's preparing for in June that's sponsored by the Ypsilanti, sponsored by the city of Ypsilanti, in which she's the administrator for and makes a lot of things happen for that. She understands that she needs to work at it. She does have meds that she's not receiving right now. She does have a therapist that she goes to when she's out there for some mental conditions that she suffers from. And she did put in a referral for Down Farms and mental health, in which she told me that
For Don Farms
the
and
outpatient-
mental health too.
No,
Go ahead.
okay. The Washington mental people gave me an intake.
For Don Farms.
Yes, sir, for the outpatients in on Gulfside.
So respectfully, Your Honor, we're just asking that why is an honorable court give Ms. Gurma give Ms. Gurma a chance. Now, give her
Never
a
called me
second.
wise nor honorable.
Wise.
But go ahead.
Give Ms. Gurma a second opportunity, and she will prove to this court that she can abide all bond conditions.
Yes, sir.
Any response from the people?
Judge, I believe that you changed your bonds because of contingency use.
Yeah.
And what she's doing in the jail is admirable, and I think that she can get started in the process now.
What I'm gonna do, just listen to, I'm gonna deny your request. However, I will sign, if I have not, a release to treatment. Okay? What's wrong, Ms. Gerber?
This will be our 5th event,
I know.
and it's in honor of my nephew who was killed on Thanksgiving in 2021, and all gun violence families, survivors, and the community.
But hold it. Maybe you're not hearing what I'm saying.
Shut up. I'm gonna shut up.
No, you can talk to me. I don't have a problem with that. The release to treatment I'm not saying that it has to be inpatient treatment. I'm saying she can be, but she's gonna have to be released to treatment. It sounds to me like you started that process. So if we can get that all worked out, I'm not gonna have a problem with that, because that's really what you need. And although you're trying your best, you can't do that on your own. That's just the reality. And you know that as well as I. Okay?
Okay.
So, counsel, if you get me a release the treatment order, I'll sign.
All right, thank you. Thank you, Your Honor.
All right, and for her, it can be inpatient or outpatient treatment, but I want something structured around her before I'm even gonna consider releasing her for whatever reason.
All right, sounds good, Your Honor. Thank you.
Thank you. Court does call the case, People versus Mario Taylor.
And good morning, Your Honor. Good morning to your fine staff. May it please this most honorable court, Edward Martell, P 85051, on behalf of Mario Taylor, who joins us via Zoom. Mr. Taylor, please state your name for the record.
Mario Taylor. Good morning, Mr. Simpson.
Thank you. All right, what are we doing?
Judge, discovery is complete. We're asking for a preliminary examination date. Please and thank you.
This is the moment the courtroom changes. The judge stops being patient. This is no longer a warning. Every word now carries consequences. One wrong move, and freedom disappears.
Pardon, sir. People have their witnesses available March 3rd.
Yes, Your Honor.
Preliminary examination in person will be set March 3rd, 2026, 9 a.m. before Judge Freshout.
Your Honor, I don't know if it's possible. Would it be okay to have it set before Judge Perry? The only reason I'm asking is because co-defendants have exams set for the same date before Judge Perry. It's the same witnesses.
Co-defendants have?
Yes.
All right. If co-defendants are set, there's no reason for me to set it before two different judges. I'll set this before Judge Perry.
Thank you.
Bond will continue.
Thank you, Judge.
Thank you.
Have a great
Case
day.
People versus Ernest Gardner.
Sherilyn Foster Tucker on behalf of Ernest Gardner.
I did, yeah. Your name, sir?
Ernest Gardner.
All right, what are we doing?
Your Honor, we're requesting a preliminary exam. Discovery is complete to my knowledge.
People have witnesses available the 3rd. Preliminary examination in person, March 3rd, 2026, 9 a.m. This will be before Judge Freshour.
Thank you.
Council should be aware, although it won't matter for me, there was a communication sent from the defendant to the court, which the court has a copy of. I don't know if you have copies.
I don't.
All right. Thank you.
Thank
Don, continue. Court calls case People versus Jacob Grammatico.
People, Your Honor.
And good morning, Your Honor. Joseph Hall, appearing for on behalf of Mr. Grammatico, who currently stands to my right. Mr. Grammatico, if you could state your name for the record.
Jacob Grammatico.
Thank you.
And Your Honor, at this time, people are unable to proceed as to count one, would ask the court to remand down to district court on count 2.
No objection.
Count 1, you're moving to dismiss.
That's correct statement, Judge.
All right, dismiss. I'll continue as not guilty plea as to count 2. I'll set a pretrial in that matter,
March 18th at 9 a.m.
March 18th, 2026, 9 a.m. That is before me. Do you believe? Well, now, this wouldn't go to the 18th. This is a DV.
I apologize. March 2nd. At 1 p.m.
March 2nd, 2026, 9 a.m. before me. Thank you.
Oh, at 9 a.m.? Okay, I can.
Yes.
I can make.
All right, I'm sorry, 1 p.m.
1 p.m., even better.
Thank you.
So that I could make you happy, Mr. Hall.
I knew you were trying, Judge.
Yes, I was. All right, thank you.
Thank you very much, Your Honor.
Yes, yes,
Your Honor.
Court calls the cases of the people versus Kawandake, yeah. Thomas.
And Sherilyn Foster Tucker on behalf of Ms. Thomas in the cases ending in 1211 and 5653.
And Michael Gaddy, Assistant Public Defender in the cases at 1945 and 5565, Judge.
All right. Okay. Your name, ma'am?
Hello, I am Kiwana Place, Cynthia Rose Thomas. Good morning, Your Honor.
All right, what are we doing?
Your Honor, Ms. Thomas understands that she has an absolute right to a preliminary examination. She wishes to waive that right and seek a global resolution in circuit court to her matters. I do have an executed advice of rights. I have advised her of her right to an exam.
And same for my
When
matter.
you're 50s. These are all 1 pound. Ma'am, you understand you have a right to a preliminary examination?
Yes, Your Honor.
You understand that by waiving that hearing, that, I should say, you understand that that's a proceeding where the people would have to show by the standard of probable cause that the offenses alleged were committed and that you committed them. You understand that? If
Yeah.
you don't, tell me you don't, and that's okay.
Yes, I understand.
All right. You understand that you will not have that hearing and that you'll proceed to circuit court for further resolution of all 4 matters. You understand that?
All 4 matters or all together?
Well, you have 4 cases, I think, for me, and each has, I think, 1 count on it. So
Okay.
you'd be going to circuit court on all of these 4 charges in these 4 cases. You understand that? For them to be resolved there.
Your Honor, I think the confusion may lie that she has 14 matters total pending in all the courts, and she's waiving these matters up, and we're going to seek a global of all of those.
Got it. But are the other 10 then already up?
They're misdemeanors.
Oh, they're misdemeanors. I got it. Okay. So they're trying to resolve all your cases.
Yeah.
Got that? You understand that part?
Yes,
These cases that I have before me are all felonies.
yes,
So they're trying to get all of these up to circuit court.
yeah,
And then I think the plan, whether it works or not, but the plan is to resolve these 4 cases as well as your other cases, all with 1 big resolution.
right,
Okay, you understand that?
yes,
Okay. And so you understand that a preliminary examination or that hearing, you're not going to have that. You're going to go up to circuit court
yes,
so they can try to resolve everything.
yes.
Okay. You have any other questions regarding that?
So is there, if I bring these cases up, is there a chance that it's going to be separated then?
What do you mean?
Like these 4 from all the other cases?
Well, they're already separated anyway, because I think your other 10 cases, they told me are misdemeanors and so
Oh, okay.
they're in district court. And they're trying to get all 4 of these up to the circuit court
Yeah.
judge, and they're
Oh,
just
wait.
gonna try to resolve everything.
We're gonna try
Yes.
to resolve everything, but they're all in different courts.
Okay,
You okay?
yeah.
You understand all of that?
Do I go home today then?
Well, I don't know that that'd be the case, but.
Yeah, I understand.
You understand. All
Yeah.
right. People also waive their right.
Yes.
Preliminary examination having been waived, defendants bound over on a single count in all 4 cases.
Your Honor, in terms of the public defender cases, we waive reading, stand muted on the arraignment of the information, acknowledge receipt.
We'd also waive formal reading, acknowledge receipt of the information, and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in these matters will be set for
March 2nd at 1:30 with Judge Hamid.
March 2nd, 2026, 1:30 before Judge Hamid. Bond will continue. All right.
Thank you.
Thank you. Court calls the case, People versus Michael McClure. Your name?
Michael McClure.
Who is it? Joe?
Yeah.
It's like a squirrel. Just took off. Well, no, Miss Constantino ran out to,
She's a little more swift.
yeah, she's little. She'll get lost in the hall. Okay, there he is.
Lost in the hallway.
Well, no, we were not concerned about, well, everybody was concerned that Miss Constantino wouldn't make it back.
Good morning, Your Honor. Joseph Hall appearing for on behalf of Mr. McClure, who stands to my right.
Your name?
Michael McClure.
All right. You're requesting an adjournment?
That's correct, Your Honor, to review discovery. I was recently retained in this matter. I have received 6 videos. I do believe there may be call for service and dispatch that I have yet to receive.
March 12th, 2026, 9 a.m. Bond continued.
Thank you very much, Your Honor.
Thank you.
Yep.
Court calls case People versus Corey Blair.
Alexander, on behalf of people here.
Public Defender Chelsea Virgils, with and on behalf of Corey Blair, please state your name.
Corey Blair.
Thank you.
Your Honor, we're asking to set a preliminary exam in this case. I believe all discovery is complete.
Yes. Would the people have their witnesses available on the 3rd? Preliminary examination in this matter will be set for March 3rd, 2026, 9 a.m. before Judge Perry. Yes, as
Your Honor, to my attention, this defendant has made 61 calls to the victim through her listed number from his PIN since he's been arraigned. So at this point, I'm going to be asking that his phone privileges be revoked.
Any response?
Your Honor, Ms. Senda did make me aware of that allegation yesterday. I haven't heard these phone calls. I would ask for a hearing on that.
All right. Well, I'll tell you what, you can. I'll set the preliminary examination as well as a hearing on the bond violation before Judge Perry on that date. That would seem to me to make most sense. And then I will order that the defendant's phone privileges are hereby ordered revoked pending that hearing. Yes.
Okay.
Until we can also get it straight, counsel, I'm not only revoking his phone privileges, I'm also revoking any texting privileges that he may have at this time also. Thank you.
Thank you.
Case People versus James Kearney Senior.
Morning, Your Honor, Raymond Cook with People.
Well, are there 2?
Yes.
Are they both on today?
Yes.
This says senior.
Sherilyn Foster Tucker, standing in for attorney of record Ed Drukas on behalf of.
You were born the last day of 76. Yes, you take the ends out of your pockets. Oh. All right, then that's
Okay.
the one I call.
On behalf of James Kearney Senior.
All right.
Say your name.
Oh, James Kearney Senior.
Thank you. All right, what are we doing?
Mr. Drukas is seeking an adjournment. I believe there is a resolution. He just needs some time to finalize it.
Probable cause conference and will be adjourned to March 12th. 2026, 9 a.m. Bond continue. Thank you. Court calls case People versus Kenneth Dorsey.
Michael Gaddy, assistant public defender. Approaching.
Your name?
My name, Kenneth, Dorsey.
Thank you. What are we doing?
Your Honor, I've gone over his right to an exam with Mr. Dorsey. He understands he has the right to preliminary exam. He wishes to waive that exam and seek resolution in the circuit court. I believe upon waiver, the people in circuit court would offer to dismiss one count in exchange for the a plea, and the other would not object to either.
So you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes,
And you understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
yes,
People also waive their right.
Yes.
Preliminary examination having been waived, defendants bound over circuit court on both counts. Mr. Gannon.
Your Honor, we'd waive reading, stand mute on the arraignment on the information, and we acknowledge receipt.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
March 2nd at 1:30 with Judge Hamid.
March 2nd, 2006, 26, 1:30 before Judge Hamid. Bond will continue. Thank you. Court does call the case of the people versus James Kearney Jr. James Kearney Jr.
right here.
Anna Mackey, requesting permission to practice under Michigan Court Rule 8.120 under senior assistant, public defender Joy Gaines.
She's here, it's fair. Permission to practice is granted, Ms. Smith. All right. Your name, sir?
James Kearney Jr.
All right. What are we doing on this? Requesting an adjournment?
Yes, Your Honor, we're requesting an adjournment and we'd like
Ms.
to.
Mackey was doing a fine job.
Oh,
No, she really was. And
she was.
she was.
But we're all,
She was. I don't know why she went and sat down.
I don't know, Your Honor.
Why'd she do that?
I don't know. She's maybe.
You should have
maybe
made her,
she's
you should
getting-
make her get back up here. She just left the podium. Didn't say goodbye, Judge, didn't say anything.
Joy Gaines, Senior Assistant Public Defender representing James Kearney Jr. And Your Honor, his father is out in the,
Who?
he is present by Zoom.
Oh, yeah, he's right here.
Yes,
He's been here for a while.
yes, he has.
And he stated his name.
Yes, so we are asking for an adjournment so that we can discuss with him the offer. We are also wanting to address bond. At this time, there's a no contact order with his father and that he cannot return home. I was hoping to see if his father was able to stay for a minute in case you have questions for him. My client is 18 years old and his father.
Go ahead. I'm sorry.
And his father did indicate that he wishes to have his son.
This is the moment the courtroom changes. The judge stops being patient. This is no longer a warning. Every word now carries consequences. One wrong move and freedom disappears. 10-year cap. But the judge reviewed everything carefully. The victim was 16. The law is clear. No excuses. 2 years in prison. Lifetime registration. No legal re-entry into the US. The judge's message? The law is the